Welcome to Reddit Aliens. Lawyers of Reddit, what is a detail your client failed to mention that lost you the case? Please remember to like, share, and subscribe. He'd sent a photo of his wife's beaten face to his wife with a message saying something along the lines of, "Do you want this to happen again?" He came across very well in court up to that point, but his mask slipped when that came out. A buddy of mine's case as a public defender. A gal was busted on drug charges and told him she didn't have any drugs on her when they arrested her. He thought, okay, we'll use that. Turns out, she didn't have any drugs on her when they arrested her because she just sold them to an undercover cop. My house was robbed. In addition to all the stuff the thief took, he also stole a bunch of my suits and all of my neckties. I had a big collection, like 100 or so. However, the thief left fingerprints on a hard plastic box that I kept spare change in. Fast forward 3 months, the thief is caught in the act of robbing another house in the same neighborhood. Same detective on my case, and this new theft. They fingerprint the guy, and the fingerprints matched the ones from my house. At the thief's arraignment, I see him stroll in wearing my suit and tie. I tell the district attorney, he says there's really no way to prove it. However, the tie he chose to wear was one-of-a-kind street map of San Francisco, and I still had all the documentation to prove it. The district attorney's eyes widened, and he informs the judge. The judge has the thief placed under arrest again for possession of stolen property. The thief's lawyer was dumbfounded. It was a nice end to a rough situation. Little late to the party, but here goes. An obligatory not my client. The company I worked for at the time was doing due diligence before acquiring a small tech startup. The COO of the tech startup was a well-liked guy in the company, friendly and outgoing, though we had heard rumblings that the COO was rather hands-on with the work with the female employees. Apparently, there was a walkaway package proposed to the COO that would let him keep a sizable portion of his post-acquisition bonus because a young woman who worked in their sales department had filed HR complaints against the COO and obtained counsel. I sat in on the meeting with the COO and the company's retained lawyer while they grilled him about his contacts with the young woman. The COO denied ever having contact with her within the company without multiple other people present. Those people said his behavior towards her in the meeting didn't raise any flags. The COO emphatically denied having any contact with her outside of work. The lawyers asked the questions a half a dozen different ways, and each time the COO denied any out-of-work contact. Later, we meet with the woman and her lawyer with the COO not present. Her lawyer gives us a rather graphic card that came with a bouquet of flowers addressed to her from the COO. The guy had an account with a florist linked to his credit card. When the company retained lawyers confronted him, he said, "But I never had contact with her. It's not like I deliver the flowers myself." COO got terminated for cause, so no walk-away package. At her request, the woman was given PTO until after the acquisition, then moved to another one of the companies under our umbrella. Well, it looks like that COO got everything he deserved. Nothing. That's it. Employment case. We got to the deposition of my client and all set up. The first question is, "Please state your name." The client looks at me and says, "Can we take a break?" We do, and she pulls me out into the hall to tell me she's lied to me about her identity. She's apparently a serial fraudster and has changed identity 7 times since the 90s. She apparently thought the other attorneys had somehow figured it out, and that's why they asked the question. Lawyer in the UK. I acted for a member of a famous pedophile hunting group. My client was charged with various offenses relating to his vigilantism, most seriously causing grievous bodily harm with intent. He wanted me to fight the case on a public interest defense point that is not available to him in a statute or at common law contrary to my advice. I followed his instructions as I'm bound to do. If the state won't punish pedophiles properly, then it's left to men like my client to take the law into their own hands, a horseshit argument for a whole host of reasons. His laptop was seized by police and submitted for forensic examination. He had a staggeringly huge database of child pornography on it. He himself was a massive pedo. Minor traffic cases can be the worst for this, believe it or not, because they are short and simple, and oftentimes the client isn't there. So if you get blindsided by something critical, there's often no chance to consult with them to turn things around. I had a simple speeding case, 70 miles per hour in a 55, no big deal. If she does a driving improvement course, the court will usually dismiss or reduce those, since her driving record wasn't bad. When I showed up for her, I found out that she had been driving 70 up and unplowed snow lane to get around all the other cars traveling in the lane that had been plowed because they were driving too slow. I didn't know it was even possible to drive 70 on fresh snow. The officer stated he'd already cut her a break by not writing the ticket for reckless driving, and the judge politely agreed he didn't feel comfortable reducing it under those circumstances. When I called her up after the court to confirm, she did claim she'd just forgotten to mention it. Now, maybe I've lived too much of my life in the South, but that just boggles my mind as a detail you'd forget when hiring a lawyer for that incident. I would have told her in advance that hiring us was a waste of money, not to mention the hassle of taking an 8-hour class, and she should probably just go ahead and pay this one. I legitimately do that all the time during consults, give my honest assessment if the case is even worth doing, and so by omitting that detail, she harmed herself for no reason. At least she took it well and didn't get defensive. A friend of mine is a defense attorney. He was representing a guy with a lengthy record for assault. Basically, this guy took an AC unit and threw it at his girlfriend. My buddy tells me he was able to get a plea deal for 1 year probation, no jail time. The judge is all ready to accept the deal when he asks the defendant if he had anything he would like to say. The defendant responds, "Yeah, I don't know why they're charging me with assault. I never touched her. I just threw an AC at her. This is bullshit." Judge rescinded the plea deal because of defendant's attitude or lack of remorse, went to trial, and got a year in jail. Client said his ex owed him a lot of money and that she was trying to get out of paying him back by getting a protective order against him. Seemed reasonable, so I took his case. At the hearing, it came out that they were never a couple, that he was sending sex toys to her residence on a weekly basis, and that she never asked for the thousands of dollars he gave her over the years. Stripper. We lost. He got laughed out of court and learned a valuable lesson. Tell your lawyer the good and the bad stuff before trial. There's so many. My dude in a custody battle where the opposing party claims he has a drinking problem and he denies it 1000%. Even after the real talk I have with him, asking him to not hide shit from me and to be honest, we go into court and at cross-examination, the opposing party provides video evidence of him finishing work, driving to an abandoned parking lot to drink a few tall boys, and then going to pick up his kid from school. Oof. Every single access visit. He not only didn't tell me that, he forgot to mention that his ex-brother owns a private investigator firm. Effing idiot. Case as a paralegal. Negligence case. Client argued that a lack of streetlights and a cyclist he couldn't see was responsible for him hitting a wire pole. Upon discovery, the first respondent's report indicated that they found the driver in the driver's seat, pants down, with porn playing on the phone. Wasn't difficult to figure out who was negligent at that point. Guy in prison hired me to request a modification of his sentence because he was doing very well, completing a lot of optional programs, no rule violations, etc. He had his family come in and pay and everything to get started. I asked the family and the client if he had requested modification before, because the law said that for his conviction, he could only request modification twice for any one sentence, regardless of if they were granted or denied. Swore up and down he'd never filed before. You can see where this is going. After spending a few hours going over records and preparing documents, a copy of the CCS, the case record basically, finally arrived. He'd personally filed for modification 6 times since he was sentenced with handwritten pleadings that were all denied. So the one he hired me for was a waste of time and would never be considered at all. I'm a court-appointed attorney for qualifying individuals in family matters. Termination of parental rights case. Have been fighting to argue that parent is stable, working lawfully, has a suitable apartment, doesn't need psychotropic meds anymore, ready to be a parent, etc. After a few months of negotiating with all the parties and Department of Children and Court Services, we have a pretrial to try and convince guardians. I meet with my client before the hearing to see if anything changed. Nope, all good, let's get my kids. Great. That's not happening today, but let's try. We get going in court. My client, who is super hot-headed and quick to anger, gets riled up and goes off on the guardians, screaming in open court. It doesn't end there, but reveals 1. That no longer is working, 2. No longer an apartment, 3. Doesn't want to have a relationship with guardians despite her kids loving them, 4. Won't send her kids pictures of the toys they miss and can't have, 5. Plans on moving out of state, 6. Thinks they can live as a family off of state aid when she gets them back, and is 4 months pregnant, all in a matter of 15 seconds. I was too shocked to even react, speechless. Not the image of stability and parental fitness I've been trying to paint since last July. Family court is a painful, sad place. I just hope in this case that the guardians maintained guardianship over these children and not back to that parent. Not my client, but the son of the opposing party, and presumably the party himself, lied about being blind to make himself seem more sympathetic as a witness. We didn't know either until he took the witness box. Their counsel asked him to take the oath, and he picked the card up and read it. That was the cherry on top of a series of ridiculous events. The judge dismissed the whole thing in our client's favor shortly after. I was a trainee at the time, but my boss, who was in her late 60s then, said it was the most ridiculous case she'd ever handled. I wasn't a lawyer in this role, but was a law clerk. This was a typical divorce case. This particular jury trial was about splitting assets and who would get what. It was a long, drawn-out case that took about 5 days. Right before the closing arguments, the attorneys wanted to talk to the judge. It seems as though a couple of days prior, the couple decided to get back together, and instead of telling the judge and their lawyers, they just kept it a secret. We heard 4 days of evidence, arguments, brought in experts such as land assessors, financial planning people, and the like, and they were back together. One of the attorneys asked to be dismissed from the case immediately and walked out of the courtroom. The judge had to dismiss the jury, and then the couple was adamant that they didn't think that them getting back together was a detail any of their attorneys needed to know. I'm a public defender in an area with lots of meth use. Meth makes people talk a lot, so I can't tell you how many clients forget to mention that they got to the jail still high and called their mom, girlfriend, buddy on the recorded jail phone and not only confessed to the crime, but also brainstormed whatever alibi or version of events I'm relying on to defend them. Credit card theft or fraud case. When I was a young lawyer back in the late 80s, I was trying this guy on a CC case, and the witness was the department store clerk. Before video surveillance, the state relied heavily on witness identification. As she described the customer that was purchasing the very unique clothing her store sold, I asked her how could she be so sure it was my client. She looked at my client, who was wearing the most obnoxiously yellow shirt imaginable, and said, "Because not only does he completely match the description I just gave you, but he's wearing the exact same shirt I sold him." The jury convicted him, and I learned that day to better prepare my clients for trial. There's a rule you're supposed to follow while questioning trial witnesses, and that rule is never ask a question you don't know the answer to. Despite this rule, lawyers often ask small, apparently inconsequential questions which are necessary to set the scene, but are so inconsequential or obvious that the answers are fairly presumed. This case was an exception to that general presumption. The defendant was arrested on a warrant and transported to jail. After booking him into jail, the officer returned to his vehicle and discovered a baggie of drugs sitting right in the middle of the back seat. The defendant was charged with possession. At trial, the officer explained that he routinely searches his vehicle before his shift starts and after any time he transports someone in the back seat. The defense attorney tried to poke holes in the story, but these officers' testimony was remarkably consistent. The officer was fastidious about checking his vehicle. The appearance of the drugs coincided with the defendant's presence in the vehicle. Then, as the defense attorney was running out of questions, he threw out the question. Was there anyone else in the back seat of the vehicle? It was a Hail Mary. Even when there are multiple arrests, police tend not to transport more than one arrestee at a time if they can help it. There was no reason to believe anyone else could have feasibly been in the backseat with the defendant. Though it's no surprise to you, the defense attorney and prosecutor were stunned when the answer came back as a yes. Turns out, the defendant was with his girlfriend when he was arrested, and the officer courteously agreed to drive her to her apartment before taking her boyfriend to jail. This fact was not included in the police report. The officer never told the prosecutor, and shockingly, the defendant never told his attorney. There was a palpable pause as this fact sunk in. Since there was another person in the back seat, there was more than enough reasonable doubt. Proofs were concluded, and the prosecutor threw out a half-hearted closing. The not guilty verdict was a given. Because of this case, I learned to never assume a fact, no matter how obvious it may seem. You know, all those procedural law shows on TV that we grew up watching, and some of them are still on, but the lawyer will be like, "Where were you on the," and they have this bombshell reveal every week. They never really happen, but in this case it kind of did, so that's cool, I guess, right? I am actually a lawyer, but I was only watching this trial, not participating. So the case was that a woman had hit woman B in the head with a heavy beer pint at a bar, and woman B got pretty seriously injured. The defense claimed that woman A had not hit anyone with the pint, but instead had just thrown the pint in a random direction, and it happened to hit B in the head. Thus, it was an accident and not a battery. Well, the prosecution had a CCTV tape from the bar, and it was shown at the trial. And the tape clearly showed in HD as A walked behind B and smashed the pint to her head so hard that the pint shattered on impact. I looked at the defense lawyer, and his jaw literally almost hit the table. The prosecutor also noticed this and asked something along, "Thrown, eh?" And the defense lawyer said that due to the technical difficulties, he couldn't get the CCTV tape open on his computer when he was reviewing the evidence. Woman A was found guilty. So yeah, I was completely dumbfounded. My father is a judge. I remember him talking about a case where a woman was suing for a severe back injury that she said was preventing her from working and taking care of her kids and so on. In the middle of the trial, a pen rolled off the table and she's bending over trying to reach for it from her chair, but the pen was too far away. So she stands up and bends over and picks it up and goes back to her seat as if nothing is out of the ordinary. My dad is just looking at her, and she snaps at my dad and goes, "What are you staring at?" My dad asked her if she was okay, and her response was that she was fine. Her attorney leaned over and said something to her, and she then loudly started complaining about her back and how much her back hurt, but no one believed her, LOL.